fourth webinar in a series of 4 on estate planning. Our presenter, Robert Constantine, is the Senior Philanthropic Advisor at RIT, where he engages with alumni and friends of RIT to assist them with their charitable gift planning in ways that best fit their personal circumstances and interests. For more than 25 years and prior to coming to RIT, Robert was an estate and a trust attorney and partner in the Buffalo, New York-based firm Damon & Morley, now known as Barclay Damon. Robert's law practice focused on tax, estate, and charitable gift planning for families, business executives, medical, and other professionals. He was admitted to New York and Florida. From 2003 to 2010, he was Regional Manager of Trust Administration with HSBC Private Bank. Robert is a graduate of the University of Pennsylvania and earned his JD and MBA degrees from SUNY at Buffalo. He is an elected fellow of the American College of Trust and Estate Council as well. Robert, we are thrilled to have you back yet again. Let's get started.
Thank you, Cindy, and thank you very much, everybody, for joining us again today. As I mentioned, this is the fourth in a series of, fourth in a series of presentations that I've had on estate planning topics. Here's the list of the series, but in general you can go on to youtube.com and just do a search for RIT webinar and then put the word estate in, and I think these will come up. Each of them were intended to approach the estate planning process from slightly different perspectives, and there's a significant amount of overlap with those. But I think that if you're interested in getting a good feel for this, listen to each of them over some period of time. They are cumulative, and hopefully you'll pick up some ideas that will be helpful to you. Well, let's step ahead here. Let's talk about surprises. Surprises are great at birthday parties, but I have to say they're not great in the estate planning process. That's what we're doing the planning for. We don't like surprises. Let me give you an example of a situation. I'm using the names of John and Carol here, who got married, had a child called Sonny, and that both have pursued pretty successful careers over a number of years. And after some period of time, Carolyn decided there were greener pastures elsewhere. Stepped out of the family in all ways, and ultimately there was a divorce. John went to his attorney, changed his will, in this case eliminating Carolyn from the estate plans entirely, and providing for Sonny, who at that point was a young adult, and ultimately for Sonny's children, should he get married or should he decide to have children at some point. John ultimately died, and it was discovered, however, that he never bothered to change or never thought to change his beneficiary designation on a very substantial IRA that he had actually been adding to over all these years, even after Carolyn left. And what was the result? Well, the result was that Carolyn ended up with a substantial windfall, $1 million, that she, and in this case, her new husband, enjoyed many years using. For some reason, the animation isn't working on these slides. Animation won't work when we upload it. Okay. All right. Now, that is, a number of states actually have some provisions for that when you get divorced, and if there is a will provision for a spouse, the divorce will automatically result in the spouse being treated as having predeceased if you don't get around to changing the will. So whatever provisions follow a predeceased spouse will come into play where there's been a valid divorce. However, IRA and life insurance and things like that are actual contractual assets. So I just went back to the prior slide here for a second, because those are contractual relationships between you and Fidelity or whoever it happens to be who has the IRA. They're not controlled necessarily by the laws of any one particular state, because these are companies that operate in all 50 states and beyond. So they like to be bound by the terms of their contracts that they draft up themselves. And if a beneficiary doesn't, if a owner of the fund doesn't bother changing the beneficiary, that's not Fidelity's problem to look into the circumstances, and there usually is no provision for what happens in the event of divorce. The purpose of all this is in saying this and tell you this little story is that you need to do the planning, and the planning has to be careful and it has to be done in concert with knowledgeable professionals. So today's lesson plan might be that if the worst outcome can happen, it will happen without planning. Not every one of the beneficiaries who you designate are going to have the experience and the wisdom to be able to handle large inheritances. Now, what does the term large mean? Well, that's entirely what you believe it means. Somebody who may consider a $20,000 to be a large inheritance, and others may consider sums substantially north of that. Next, you may disinherit anyone almost, and you'll see here in the next slide or two that that's not everybody, but you may disinherit anyone you want in most cases. So you have a child that is estranged, or a family member that has taken themselves out of the picture, or you want them out of the picture. They do not have a legal right to inherit if you have made provisions that direct assets away from them. And you may provide for anyone or anything. I did years ago a trust for a cat, where we actually set aside the sum of $10,000 and gave it to the person who would ultimately have custody of the cat, and that provided for medical care, food, and other things. Today we're going to cover planning by beneficiary category to a certain extent. We're going to talk about the kinds of planning for spouses, for non-married partners or friends, and how that might differ from the planning we do for spouses, for children, other descendants, grandchildren, for your community, the charities that you currently support and that you want to establish a legacy or a continuation of that lifetime of support. There are certain things that are unique with certain types of beneficiaries, and so today I'm going to try to address some of them. So at this point, let's go into the first question. I've got a question for you. It helps me understand who's on the phone as far as what your interests might be. So the question is, you've joined us today because you are most concerned about the planning for, and then I just want you to check any or all of these that may apply. You know, primarily I'm interested in planning for my spouse. Primarily I'm interested in my children, grandchildren, my spouse and grandchildren, non-spouse. Well, you can read the rest, community, charity, or last, some combination of all of these. So if you would fill that out, I would appreciate it. We'll take a look at that as the answers come in. As with any kind of planning, there are trade-offs, and we're going to talk about some of those trade-offs. How and when will your beneficiaries access their inheritance? Are they capable and experienced in the handling of assets? Are they young? Are they elderly or perhaps infirmed and incapable of handling their own assets. So should the benefits that you're leaving to them be deferred in some way or held for them? Well, certainly if there's a deferral of benefits, there's a certain level of complexity that goes into the planning and the design of the plan. So we do have a trade-off of simplicity versus complexity, where we have a need for that extra level of complexity. Do we need to protect your heirs from their creditors? Predators, and these are people who might be unduly influencing your beneficiaries. And do we need to protect our beneficiaries from themselves? Are we dealing with people who have a dependency issue or irresponsibility that they need some self-protection? When I talk about heirs, there are a couple of definitions of that. I'm using the term heirs today as being anybody that you designate as a person that you would like to receive benefits from your estate. So these are just people inheriting assets as a result of death. There's another term, heirs, heirs at law, which is roughly the equivalent of blood relationship. So you have natural heirs at law, spouse, descendants, children, grandchildren, whatever. If none of those, you've got parents, you've got siblings perhaps. So those are heirs at law. If there had been no will, if you made no planning whatsoever, the heirs at law generally will inherit in accordance with their proximity to you, the relationship. The closer they are, the more they inherit, and the greater percentage they inherit. And I'm going to talk a little bit about that in a minute or two here. And then necessarily, and not surprisingly, and as I look at the results, which you can see as well, you know, we have multiple groups that we want to benefit, and some combination of spouse, family, community, friends, partners, things like that is most common in planning. When you're an attorney, you see that as being probably the most common scenario. So where you have planning for multiple beneficiaries, that is another piece that I'm going to try to get to as we go along here. So we're going to cover these things today. Let's start out with some estate planning basics. Number one, you need to know what you have. And in the prior webinars that I did, I made available a questionnaire that you can use to collect information about yourself, about your assets. We will have those available for all the participants here also, and we'll send them out to you as long as you provided us with an email address, which you have. But know what you have is important, because if you don't know what you have and how the title on these assets is held, you're not going to be able to do effective planning. If we go back to that earlier example that I did about John and Carolyn, had he set down on paper all his assets, it would have been fairly obvious, or if the attorney had done the job that he or she was supposed to have done, you would have inquired about retirement accounts, and the attorney should have alerted him that you've got a beneficiary designation form that you need to update to remove Carolyn. So know what you have. Second, know who you want to benefit. That sounds like a truism, but you'll see when we get into it in a minute here that knowing who you want to benefit is extremely important. You need to understand their needs and the capacities of the beneficiaries. We can't just assume that everybody has infinite levels of capability and maturity and will do what you would hope that they would do to best utilize the inheritance that you're providing them and lead a long and productive life. Finally, with this information, We want you to work with professionals to implement the plan. Another handout that I used in the earlier webinars was a series of questions that you might ask of an attorney that you are interviewing or working with about that attorney's estate planning background. Kinds of questions that help you evaluate whether the attorney is knowledgeable, in your opinion, and if the attorney has the requisite personality, someone with whom you would be comfortable working. Got to know your beneficiary. Whether family, friend, whomever your beneficiary might be, is your beneficiary able to handle a sizable amount? Do they have a level of maturity? Financially, are they financially experienced? Do they happen to be incapacitated, or are they in an age where they might be approaching incapacity, or are they at an age where, frankly, they are not actively monitoring their assets, so it would be best to have them monitored by a third party, a trustee, which is a term and a concept we'll discuss also later on. Are they at risk of loss of their assets to creditors? Are you passing over assets to someone who has significant outstanding indebtedness, is being chased by creditors, legitimate creditors, and is the inheritance that you're providing that beneficiary merely going to be transitory, and is it going to end up in the pockets of ABC collection agency? And then I also mentioned earlier about the concept of predators. There are people out there who have a nose for learning when people with weaker personalities have inherited or come into money, and they will take advantage of them. Are we dealing with a beneficiary who's involved in a shaky marriage, however that might be defined? Normally, assets that are inherited do not form part of the marital estate that gets distributed on divorce. Nevertheless, the mere fact that someone receives assets, they can cause it to become marital assets and therefore subject to split on a divorce. And it doesn't take a lot to bring them into the marital estate. They can literally put them into a joint account, or even have the income going into a joint account can in some cases be enough to draw those assets in and make them available in the negotiations when a divorce is started. And then I'd like to talk about this Ferrari syndrome, which is the concept that that 18-year-old, through improper planning, ends up with a chunk load of cash, and a week and a half later has a new Ferrari in the driveway, or a Porsche. And I can tell you absolutely, unqualifiedly, that I have seen it happen. This gets more to the point of instilling in your ultimate beneficiaries some understanding, to develop some financial responsibilities so that when they do receive assets, they do not feel compelled to spend them down immediately. As you evaluate, part of the process here of knowing your beneficiary is being honest to yourself. Honestly evaluate each beneficiary, and then candidly discuss the issues with the attorney from whom you're seeking advice. I can't tell you how important it is, first of all, for an attorney to be actively probing you for information about the beneficiaries, including their whereabouts. Well, you know, I love my son. Oh, really? Where does he live? Well, I'm not sure. I haven't heard from him for 17 years. Well, how do you propose we're going to go find him once you're gone? Well, I'm not sure. So these are, you know, some cases, if the attorney doesn't ask the questions, you know, you not necessarily have any reason to bring them up, but you're now aware of it, so you're all going to be responsible for raising these issues, aren't you? If charities are beneficiaries, how stable is that charitable organization that you've identified? is that particular charity going to be around, going to be able to accomplish the purposes that you would like them to accomplish with the money that you intend to provide them? You may determine at some point that this particular agency, maybe a local one, and maybe on a little bit weak legs, that you love the mission, but you're a little bit concerned about their ability to continue. You can still benefit them, but perhaps you're benefiting them more by not having the assets go directly to them, but rather by having the assets go into a community foundation fund that will ultimately can be flowed through to that organization, or if the organization is no longer around, the community foundation fund can be designed by you to benefit other organizations that will address the issues that you think are most important. Another concept is to establish a donor-advised fund. RIT happens to maintain one for RIT's purposes and other organizations, or you can find other donor-advised funds, but then you'd need to have a family member or somebody designate the charities that will ultimately receive grants out of that fund. Let's look at the spouse as a beneficiary. The spouse has rights of inheritance. Remember I said earlier that you can disinherit almost anybody. Well, you cannot entirely disinherit a spouse. States will determine the amount that a spouse will receive if there's no will. So we talked about heirs at law, and the states have a series of statutes that called intestate succession, which govern how assets will be distributed when there is no will or other dispositive instrument like a living trust. So in this particular case, not surprisingly, if there's a spouse but no children of the deceased parent, so think for a minute maybe a second spouse, and there are and the parent who has died has no children, then the spouse receives everything, not surprisingly. If there are spouse and children, even if they're not the spouse's children, then the first $50,000 in New York, plus 50% of the balance of the assets after payment of funeral expenses and attorney's fees and taxes and debts and those things, but 50% of the balance will go to the spouse. Where's the rest go? It goes to the children. How old are the kids? 6 and 8. What do you think is going to happen with those assets when you have a 6 and an 8-year-old? It's not something I want to get into at this point, but you can understand this would be a compelling set of circumstances for making sure that there is a estate plan in place, have a will or a trust. Now let's take the situation where there is a will and the decedent, the person who dies, has decided to disinherit the spouse for reasons best known to that person. Assuming that when they got married there wasn't a prenuptial agreement or a post-nuptial agreement between those people by which both of them waived the right to an inheritance, assuming there is not one of those, then even an attempt to totally disinherit a spouse will not be 100% successful. It will be partially successful, but not 100%. And the mechanism for this is the spouse would go to a court. In New York, it's called the surrogate's court, and would file a right of election and elect against the estate. And I'm calling it a reconstituted estate because basically what they do is they fabricate, the court says, okay, let's look at all the assets, let's look at how they pass. Well, we have some joint assets here that pass to a brother, and we have a life insurance policy that passed to a charity, and we had retirement accounts that they left to a nephew. We're going to pretend that all of these are back in the estate, and the spouse now has a right to elect and to take outright the first $25,000 of cash, plus the greater of 1/3 or $50,000 of whatever is left, once again, after debts and taxes. In addition, they get the automobile, the decedent's automobile, and then lots of the household personal items. So beyond that, however, the rest of the estate can pass away to others than a spouse. So 1/3 is basically the number I think you want to keep an eye on as far as disinheriting, if that makes sense. And this does happen from time to time. You get people for religious reasons who are married and never get divorced but have been living separately for years and years, and it's just generally understood that the assets are not going to go to either one of them. And yet, surprise, surprise, when one dies, the other reappears. So how do we plan for a spouse? Well, the most common method is obviously everything that I have goes to my spouse, and then, if spouse predeceases me, then it would go to kids. Okay, most common situation. And that's fine if there are no concerns that you want to guarantee that the next generation will, in fact, have some assets to inherit upon the second death, or the death of the second spouse. This becomes more of a problem, of course, in a second marriage situation where the children are from a first marriage or relationship, and the spouse is not, and maybe the spouse even has children of his or her own, and if all the assets go out to that spouse on the death of the first person, that spouse may decide that the assets end up going down to his or her children, thereby resulting in a unintended disinheritance of the children of the person who had accumulated the assets in the first place. So outright to spouse makes sense in most cases, as long as also there are no concerns about the spouse's ability to handle finances. Maybe we're dealing with an elderly couple and the surviving spouse is ill and frankly not capable of handling his or her own affairs, suffering from cognitive impairment, as I've called it here, or just inexperience or lack of attentiveness. If these are the cases, if none of these are the cases, in other words, you still want to give everything outright to the spouse, well, then there's some efficient ways to pass assets outright. And they would be by titling assets in joint name with right of survivorship, titling accounts so they pass transfer on death automatically, and use beneficiary designation forms. Now, just let me, these last items are generally referred to as non-probate assets. Non-probate assets means they don't pass through under a will. And the reason they don't pass, and the reason they are efficient is because they don't pass under a will. Generally and quickly, if you go, when you listen to any of the earlier seminars, I've explained in greater detail how the probate process works. But just recognize this, that it's a court proceeding and that there is some delay in getting the will effective because it's not effective until the court says it's effective. And so any dispositions of assets that are called for under the will necessarily be delayed until the court has admitted it to probate. And more importantly, those heirs at law have a right to come in. They're invited into the proceeding, even if they're not named as beneficiaries. They're invited into the proceeding to address, if they choose to, the validity of the will. So in many cases, I suggest that avoiding probate makes the most sense, and we've got lots of ways to do that. Nevertheless, even though I want you to avoid probate, I want you to always, 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 did I say that enough? Always have a will. So we've talked about what do we do if, as an alternative to outright gifts to a spouse, and this also speaks to other beneficiaries as we address them. We can use trusts, and trusts are, think of trusts as nothing than a legal arrangement to own assets and to administer assets. A trust is nothing but a contract. It can be a contract that is created during lifetime, in which sometimes called a living trust. It can be a revocable living trust. It can be changed from time to time. Or it can be a trust that is created in the terms of the will. So the will say, I leave the rest of my estate to my trustee to be held and administered as follows. So the trustee will administer assets that have been titled into the name of the trust, and the trustee will be the person who is charged with the responsibility, the legal responsibility to administer, to invest, and to follow the terms and the directions of the person who created that trust. And when do we use a trust? We use it to ensure that secondary beneficiaries will also benefit. That example that I used earlier. We use it where there's a need for protection that I discussed earlier. Now, trusts can be flexible as to how they distribute their benefits to the beneficiaries. The trustee can be given sole discretion. So in other words, the trustee will decide to whom and when and how much, whether it's income or income plus corpus, how much will be distributed at what time to what beneficiaries. It can be set up so that it's very restrictive, that only income will be distributed. And income may be defined as dividends and interest. New York permits a broader definition of using a percentage of the value of the trust as a definition of income. But in any event, it can be limited, restricted significantly is one way to do it. The trust can be broader, so that income plus some corpus if needed. Once again, this is usually in the discretion of the trustee as to whether something in addition to income is to be distributed. And then it can be as broad as income and corpus as requested. You can actually give the beneficiary the right to request more distributions. Almost akin to passing it outright, but nevertheless, in many cases, provides some comfort to knowing that there's a third person overseeing and monitoring and handling the affairs. So that's the use of trusts. Let's talk about when we want to include somebody who is not a spouse, doesn't have legal rights of inheritance, can't be disinherited, but we're talking about somebody who has been important in your life, either as a lifetime partner or friend, anybody, sort of a non-relative concept. In these cases where there's, once again, there's no legal impediment to leaving some or all of your estate to non-family relative. However, you have to recognize that there may be family members, and my experience is the further expanded they are, the more entitled they tend to feel. That recognize that there could be some hard feelings, and if they have a legal opportunity to question the being cut off, they may take that opportunity to hand. Once again, reinforcing the need to minimize the use of a will and therefore the probate process, and to consider using lifetime trusts or other methods of passing out your assets. And here I mentioned once again the solutions or the alternatives to the probate process to reduce the level of risk using transfer on death accounts, beneficiary designations, and establish a lifetime trust. I'm a firm believer that there is a great need for holistic estate planning. We are more than just the sum of our assets. We have certain feelings. We have strongly held opinions as to the importance of things like education, human services, and things like that. Frequently, when we establish trusts for our loved ones, we have we make provisions in there for invading principle, for using corpus for extraordinary but important needs such as education. We may delay the distribution of assets to a child or grandchild until that person has had the opportunity to complete certain levels of education. So education is deemed in that example as a priority. That's a value. That's a personal value that people hold dearly. In many instances, we have people who hold their commitments to their community, charities that they've supported during lifetime, whether it be religious, educational, human services, whatever it happens to be, veterans groups. These are strongly held feelings, and it's appropriate that if they're doing things during their lifetime, that there's a consistency. The estate plan also reflects a continuation of that with their assets after death. Some of their assets, giving a portion of their assets during lifetime, is it appropriate that they might do so in a permanent way and as a legacy when their time here on this earth is over. So there are a variety of ways to accomplish that, both during lifetime or through estates. You can give it outright. You can give specific assets. I leave my house in Canandaigua, to such and such organization, and direct that the proceeds of sale be used for the following purposes. You can give percentages of estates, or percentages or all of retirement accounts. Retirement accounts are, as you I'm sure know, are taxable accounts. In other words, every nickel that comes out of those accounts gets taxed at the highest rates in your tax return when you pull it out, or when you designate an individual as a beneficiary. That withdrawal from the retirement account will also be added on top of all other income and will be taxed at that beneficiary's highest rate. Therefore, when you're thinking about allocating a portion of your assets to family and a portion of your assets to your community, consider a smart allocation would be the taxable assets. Use those for the charity. Ultimately, your individual beneficiaries would be getting less anyway, so the impact on a gift to charity through a retirement plan it's much less on the income beneficiary. So it's a tax-efficient tool, it's a tax-efficient asset to use to make your charitable gifts. During lifetime or through your estate plan, gifts to charity can also provide income for you or for a loved one. There are trusts, just like the other trusts we discussed, but we term them as charitable trusts, that can be established that provide income to you during your lifetime, to a loved one after your death, a spouse, children, friend, partner, and then only after the death of that beneficiary that you've designated, then the assets will pass to the charities that are important to you, one or more charities. You can even give the beneficiaries the authority to designate the charities, to change the charities if that's something that you want. I did a plan years ago for a family, and the person who set up these charitable trusts for his sister and another one for a sister-in-law designated where 75% of the of the charitable allocations would eventually go upon the sister's death, but gave the sister the opportunity to allocate the final 25%. It made her interested in becoming and feeling charitable in her own mind, and also respected and acknowledged her commitment to her charitable ideas and interests as well. Charitable gift annuity is a simplified contractual relationship that provides income also. So you can set these up in a will, you can set them up in a lifetime trust, that on my death, a portion carves off and now creates a charitable remainder trust with income to my sister in that particular case. So talk actually gotten into combining beneficiaries with that prior discussion, but these charitable trusts that we talk about are sometimes called give twice trusts. You're giving some benefits to the family member or friend that you want, and yet ultimately providing benefits to charity down the road. Another type of combination, combining beneficial interests, is to establish trust for a spouse, and then on the spouse's death, passing it on to children or grandchildren, or if none, then to other individuals. So all of these techniques are basically interchangeable. The use of trust is extremely important and extremely powerful. It's a powerful planning tool. And I want you to generally understand that you don't have to have a huge amount of money to have trusts, but there certainly needs to be sort of a minimum amount to establish a trust that can be administered efficiently, and it's hard to really say what that number is. In some instances, it's $100,000 or more, and if depending on who the trustee is going to be, you will not be able to get a professional trustee, largely a bank or other trust company, to act unless the assets are much more substantial, usually closer to above $750,000, and in many cases much larger than that. When you set up trusts for multiple beneficiaries, so say I set up a trust for all of my living children, that's one way to do it. Do a single trust for several beneficiaries of sort of the same class, same age group, children as opposed to grandchildren. The thing is to ask yourself in the planning process, how long should that trust continue? Should it be a trust that terminates and breaks off as each child reaches certain ages, an age at which we have presumed that they will attain some level of maturity and financial responsibility? I've seen trusts that pay out a quarter at age 25, a quarter at age 30, 35, and 40. The trust ultimately terminates. The theory being that at age 25, perhaps they've completed school, perhaps they're now working in a full-time job, maybe buying their first home, developing some responsibilities, having the opportunity to have assets, learning to manage those assets is the start of, or maybe the continuation of the financial educational training of that child. At age 30, depending on how the child's done with the first piece, if it's gone, well, so be it. There's another piece coming. They're a little older, a little wiser. And at age 30, now maybe they've got a young family started, want to move into a larger home or add a bedroom onto the one they're currently in. There may be good reasons for deferring these at later ages, until later ages, to once again protect the beneficiary from themselves. Even if they're not irresponsible, they may be inexperienced, and because they may have made some mistakes, legitimate mistakes, or overspent, they've not necessarily mortgaged their entire future by doing so. So that's one option. How long should it last? I've seen other trusts that will continue until the youngest of the beneficiaries of that particular class reaches a certain age. The concept being perhaps that, listen, we're going to hold this as a single pot of money, just as I would as a parent, and just as I am as a parent, I'm going to use the money where it's needed among all of the kids. And until my youngest child has had the same opportunity to get through schools the way the olders did, we're not going to make any further significant distributions from the trust until that younger child has reached a certain level of and gotten the benefits. So, you know, it's fairness. It's not necessarily equality. I want you to think about fairness, not equality. If you have two kids, one of whom needs braces, you don't necessarily take that $3,500 that you use for the first round of braces on the child and somehow reimburse or give that to the other child who, through genetics, didn't happen to, you know, was born with straight teeth. So you allocate where needed during lifetime. You might consider permitting a trustee to allocate where needed after you're gone. That's why you want to designate beneficiaries who are trustworthy, insightful, and who will properly execute their discretion that you've given them to do the right thing in the manner that you have informed them you want the assets to be used. So you want to give the trustees some guidance, you know, and you can put this right in the document that said in exercising your discretion, I want the trustee to consider the needs of whatever, my children. However you want to describe this, that the needs so that everybody has the same opportunity to get through at least 2 years of graduate school or something. So you can give guidance to a trustee so that these things are allocated the way you want them to be. And then that gets into that whole discussion about when should the distributions be made during the period. And then I did say that if you choose to set up separate trusts instead of a single trust, then size is very important. If the trust is too small, the expenses will just eat it up. A trustee is entitled to receive a trustee's commission. Many of the individuals won't necessarily take the commission. Nevertheless, there are expenses. You're going to want to get the assets invested. You know, that sometimes requires that you have and pay for professional investment advisors to do that. They charge a fee. Somebody has to do an income tax return, so an accountant, you have to pay the accounting fee. So there are some expenses, and a good attorney in working with you will help you determine what is the appropriate size to consider on whether to set up a single trust for all your beneficiaries or to do separate accounts. And then also how to distribute the assets, whether it be made based on age or whatever. So, some final thoughts here. Review your planning frequently. Part of knowing your beneficiaries is continuing to monitor and understand and be aware of their status. Has somebody died? Have they reached a certain age? You've got a will that says basically it's in trust until they reach the age of 30 and then pass it outright to them. Well, are they now 45? Have they gotten married recently? Have they gotten divorced recently? That can become a factor. Have they become incapacitated in some way? Is there now reason to establish a trust for that particular person? Is this somebody who now needs protection that earlier you hadn't anticipated that they would need protection? Do some of these changes call for a revision in your plan? I would say every couple of years you should pull out your plan and look it over, make sure that the beneficiaries are who you think they are, and that your plan still makes sense. Always have backup beneficiaries. So, and this is whether you use designated, this is in retirement plans, insurance, or even in your will or lifetime trust. Something as simple as, if I'm not survived by A, my primary beneficiary, then I direct that any bequests would otherwise have passed to him shall be distributed equally among B, C, and D, for example. So always, once again, contingent beneficiaries, don't feel you're compelled to go on your the website of your IRA and fill in that little box that allows about 11 letters to be filled out. You should have be able to put as many beneficiaries in there as you choose, but make sure that they are there and check them frequently. Well, that's about it. I'd be happy to take any questions. Here's the other thing I'd like to offer to you. My email and telephone, although they don't appear on these materials, we'll make sure that they are available to you. And I'd offer to you the opportunity to call me at any time or email me with specific questions that you might have. And I will get back to you if you want to discuss things in confidence. I'm happy to do that with you. My role here is to enhance the relationships of RIT with our alumni and with our friends. Part of that is to be acting as resources for you. Certainly, if there are opportunities for you to include RIT in your estate plans, we're happy to help you to maximize the benefits to you and other family members, and to make the gift most impactful for us and most impactful for you as well. So we have a question here. What happens if the beneficiaries in the will are different from what is on the retirement plan as such? Well, each of these assets are controlled depending on how the title is. For example, assets that are in joint name are controlled by the contract with the bank. So if you set up a bank account and you open the account and it's A or B, or the survivor of A or B, then automatically on A's death, B will be the owner of the account. With a retirement plan, if you designate A and B as my beneficiaries, and if either A or B is deceased, then all will go to the survivor, will go to the other. Then that is the contract, that's the contractual relationship, and that will determine how the assets are going to be distributed. A will passes assets that are not distributed by some other method. So the only assets that end up being governed by the terms of the will are assets that are not in joint name, that are not subject to a beneficiary designation clause in a retirement plan or in a life insurance plan. So they are separate assets. They are separately controlled just by virtue of the fact as to how they are titled. The use of a living trust makes a lot of sense for people with assets and who would like to be able to control the assets during lifetime, which we all can do, really, with assets that we own, but would like a smooth and uninterrupted continuation of the administration of those assets after death. Because on death, assets that are titled in the name of the Robert Constantine Living Trust, that's the title on the bank account, that's the title on the securities account, whoever is the trustee after me will automatically have the ability to control those assets and will just continue on. And now the next set of directions in the trust will start to be implemented. So here's another question. If there is no spouse or partner or former spouse partner, then can I designate that my children only inherit my assets by way of my will? Well, you don't designate that necessarily, but I shouldn't say that. Yes, you can designate in your retirement plan that says pay my retirement benefits to my estate to be governed by the terms of my will. Now, I have to tell you that is a very inefficient way to do it, and it also is not a good way to do it if the idea is to ultimately spread out the benefits over the children's lifetimes. So that's not a good idea, but it is possible to do that. So yes, that's possible. And one other question, can the employer force the spouse to be made beneficiary of a retirement account? Yeah, actually, federal law steps in on these, and you cannot, in retirement accounts that are governed under the ERISA, Employment Retirement Insurance Security Act, they are not, you're not permitted to designate anybody other than a spouse without the spouse's permission. So if the idea is to have benefits from a retirement plan as opposed to an IRA, which is a type of retirement plan, but it's not a retirement account, an employer retirement account. So the spouse has to has the authority to deny the change of the beneficiary away from the spouse. So if the plan is ultimately to have the benefits go into a trust for the spouse, then yes, you have to get the spouse's consent, but if it's done as part of an overall plan, presumably, and the spouse is engaged with the planning, which I would always recommend, then I would say that you want to make sure that the spouse does sign off on the designation. So I think we're at the end of our time. Have I answered all the questions here? Do we have another one up there that I missed?
Yeah, no, you just answered.
No, that's the one I think I just addressed, the retirement plan. And Beatrix, if I didn't answer that fully, so certain kinds of, a retirement plan is a plan that the employer maintains, and it usually provides for a specific type of a payout over lifetime. TIA-CREF, for example, it would be an employer plan. Now, you frequently have the right to roll that into your own account, a IRA, a rollover IRA. You would need spousal approval for that to roll it over into an IRA. But once it's rolled over into the IRA, then those employer limitations are gone. Now it's totally within your control, and designating beneficiaries and arranging for payouts are totally within the control of the owner of the account, and then ultimately of the beneficiary. The beneficiary has certain rights to take out the benefits after the death of the account owner. So a little bit of a difference between a retirement account and an employee-sponsored account as opposed to a IRA. Even a 401k is an employer-owned account, a managed account, and in order to get out from under the employer's restrictions and maybe even the employer's choice of the investment manager, you have to roll that into your own personal retirement account after you leave. Okay, well, thank you very much for your time. I think we're up.
We are all done, Robert. Thank you so much for joining us yet again.
And we